What happens when two extraordinarily wealthy men want the same piece of Irish land? In most cases, the answer might be a bidding war, but this story went much further. A 751-acre estate in County Tipperary became the centre of a bitter legal battle between Coolmore billionaire John Magner and Irish-born US-based construction tycoon Maurice Regan. There were competing offers. There was an alleged handshake agreement. There was an accusation of interference. There were references in court to a so-called full frontal assault and a dark horse. There were 50,000 in cash handed over in 2 envelopes. And most remarkably, there was a text message in which Regan said he hoped a newspaper article about the dispute would give Magner a heart attack. But the original property dispute is now only part of the story. In 2026, Regan's Newtown Anner stud farm launched a new High Court action alleging that Magner and associated Coolmore interests unlawfully restricted its access to important equine services. The case has now moved into the competition law arena, and that raises a much bigger question. Did a bitter property dispute spill over into the business of Irish thoroughbred breeding and racing? The property at the heart of this story was the Barn Estate, a historic 751-acre estate near Clonmel in County Tipperary. The estate has been in the Thompson Moore family for centuries. It wasn't simply farmland. It included a substantial mansion, extensive agricultural land, and a setting that made it particularly attractive to someone involved in Ireland's bloodstock industry. One of the people interested was John Magner. Magner is one of the most influential figures in international thoroughbred breeding. His Coolmore operation is one of the world's best-known names in the bloodstock industry. In August 2023, Magner's side said an agreement had been reached to purchase Barn for approximately €15 million. The crucial evidence, according to Magner, was a handshake. Magner told the High Court that he believed the deed had been agreed to at his home at Coolmore on the evening of August 22nd, 2023. The alleged deal was subsequently formalised in an exclusivity agreement, but another buyer was already entering the picture. His name was Maurice Regan. Maurice Regan is a considerably less familiar name to the general Irish public than John Magner, but he is a major businessman. Regan made his fortune through the New York-based construction company J.T. Magan. He is also associated with the Mercantile Corp, which operates well-known Dublin hospitality venues, and he had an important connection to the world of horses. Regan owned Newtown Anner Stud near Clonmel. So this wasn't simply an outside investor looking for a trophy property. Regan was already a significant landowner and a participant in Irish bloodstock. According to evidence reported during the court proceedings, Regan became interested in Barn and eventually made a dramatically higher offer. The figure ultimately became approximately €22.25 million. That was roughly 50% more than the 15 million figure Magner said he had agreed, and that changed everything. The entire first legal battle turned on a deceptively simple question. Was there actually a binding agreement between Magner and the owners of the Barn estate? Magner said yes. The Thompson Moore family said no. Magner's case was that the parties had reached an agreement and shaken hands. The other side argued that the transaction remained subject to necessary formalities and trustee approval. This distinction was critical, because if Magner already had a binding agreement, then Regan's higher offer could potentially be viewed in a completely different light. If there was no binding sale, however, the owners were free to choose another buyer, and that is essentially where the legal battle went. Then came one of the strangest details of the entire dispute: €50,000 in cash. During the court proceedings, evidence was given that 2 envelopes containing €50,000 were handed to representatives of the Barn estate owners. The Magner side described the money as an expression of appreciation connected to matters including allowing Magner's side to access the property. The Thompson Moore side viewed the circumstances very differently, and the money was subsequently returned. The episode became one of the most memorable features of a case that had already become exceptionally bitter. As the competing bids escalated, relations between the two businessmen deteriorated dramatically. An auctioneer involved in the transaction later told the High Court that Magner had said he was at war with Regan. Magner disputed that characterization, but the language surrounding the dispute became increasingly aggressive. Regan's lawyers portrayed the Coolmore side as heavy-handed. Magner's lawyers portrayed Regan as having mounted what they described in court as a full frontal assault on the alleged Magner deal. At one stage, Regan was described by Magner's counsel as a dark force. Regan was not a defendant in Magner's original action against the Barn estate owners, but he was at the centre of the commercial dispute because his higher bid ultimately prevailed. Then came another extraordinary moment. The High Court heard evidence concerning a message sent by Regan in 2023. The message referred to newspaper coverage of the competing bids for Barn. Regan said he hoped an article would give Magner a heart attack. Regan later put the remark in context of what he regarded as a battle in which Magner had himself said the two men were effectively at war. Whatever the intended tone, the message would later become highly significant. Because after the property litigation was over, Coolmore would point to comments such as this as part of the reason professional relations with Regan were severed. In September 2025, the first major chapter ended. John Magner lost his High Court action. Mr. Justice Max Barrett rejected the attempt to force the Barn estate owners to honour the alleged $15 million agreement. The result meant that the much higher transaction involving Maurice Regan could proceed. The case had generated enormous volumes of documentation and intense courtroom testimony. Perhaps the most important consequences was this: Magner had lost the property battle, and Regan had acquired the estate. All's fair in love and war. In February 2026, Magner abandoned plans to appeal while continuing to maintain that he had acted in good faith. For most people, that might have been the end of the story. It wasn't. The next stage was much more consequential for the Irish bloodstock industry. Regan's business, Newtown Anner Stud Farm Limited, alleged that following the Barn dispute, the horses were no longer welcome at Coolmore and that access to veterinary services at the Featherard Equine Hospital was withdrawn. In May 2026, Regan's company brought a new High Court action against John Magner, MV Magner, and several Coolmore associated companies and executives. The allegation was not simply that one businessman had fallen out with another. The new case alleged breaches of competition law. Newtown Anner sought declarations concerning alleged anti-competitive conduct and argued that services, including stallion covering and veterinary hospital services, should not have been withheld from it on the alleged basis of the dispute. It also sought damages. These are allegations made by Regan's company. They have not been established merely because proceedings were issued. And that distinction is crucial. Coolmore's position is fundamentally different. According to a Coolmore source cited by the Irish Times, the decision to end professional relations with Regan was based on concerns including security, reputation, and safety. The source pointed specifically to the comments attributed to Regan, including the heart attack message. The argument from Coolmore was essentially, this was no longer an ordinary commercial relationship. If a client has made threatening or hostile comments about the principle of the business, why should that business be required to continue servicing that client? Regan's side, however, has argued that this explanation does not answer the competition question. Its spokesman questions how it could be considered normal for Coolmore to influence whether an independent stud farm could access veterinary care for its horses. That disagreement is now at the heart of the new litigation. Now, this is where the story gets particularly interesting. The first case was essentially about property and contract. The second case is about something much broader: market power. Regan's side is alleging that Magner and associated businesses occupy such an important position in the thoroughbred breeding ecosystem that refusing access to certain services can have serious commercial consequences. That is very different from saying John Magner doesn't like Maurice Regan. Competition law asks a different question. Can a powerful market participant use its position to exclude or disadvantage a competitor? And that is why the case has attracted attention beyond the original land dispute. For anyone outside the bloodstock industry, it may be tempting to ask, why does access to one veterinary hospital matter? Because thoroughbred breeding operates around extremely tight schedules. Mares are bred at particular times. Foals require specialist care. High-value bloodstock can require sophisticated veterinary treatment. And reputation, expertise, and access to specialist facilities can have a substantial commercial value. Regan's Newtown Understood argues that the withdrawal of the services has therefore gone beyond a personal disagreement. Coolmore's position, as reported, is that it is entitled to protect its business and people from relationships it considers unacceptable. That creates a difficult line for the courts to draw. Where does the right of a private business to choose its customers end, and where does competition law begin? The dispute has also reached the wider racing establishment. In June 2026, the Irish Times reported that Regan's Newtown Understood had sent lengthy correspondence to Horse Racing Ireland and the Irish Horse Racing Regulatory Board. Regan sought examination of allegations concerning Coolmore and also raised questions about starting proceedings in Irish racing. HRI and IHRB had not committed publicly to meeting Regan over the allegations at that stage. This is significant because it shows how the dispute has expanded. It began with a property, it moved into the courts, then into commercial relationships, then into competition law. And now questions have been put to the institutions responsible for Irish racing. In July 2026, the latest development arrived. Regan's High Court action against Magner was transferred to the competition list. That does not mean Regan has won. It does not mean that Magner has been found guilty of an infringement. It means the case is being handled within the court's specialist competition law framework. And that matters because the legal issues now go well beyond the original question of who should own the Barn estate. The court would have to consider allegations concerning access to services, market position, and whether the conduct complained of amounts to unlawful anti-competitive behaviour. There are really three separate stories here. Story one, the land. Did John Magner have a binding agreement to buy Barn Estate for €15 million? The High Court ultimately ruled against him. Story two, the feud. Did the bitter relationship between Magner and Regan deteriorate to the point where normal commercial dealings became impossible? Clearly, the relationship became extremely hostile. The courtroom evidence shows that just how personal the dispute became. The market. Story three. Can the fallout from a personal and commercial dispute justify cutting a rival stud farm off from services controlled or influenced by a dominant player in Irish bloodstock? That is the question that could have implication far beyond these two men. It is important, however, not to reduce this to a simple hero and villain story. From Magner's perspective, this began with a property transaction that he believed he had secured. He then watched another wealthy bidder offer substantially more. The resulting litigation ended unsuccessfully for him. From Regan's perspective, he was a legitimate competing purchaser who ultimately paid the higher price for the property. He then found himself, he alleges, facing restrictions on access to important services within the bloodstock industry. Both sides therefore see themselves as responding to the actions of the other, and that is precisely why this dispute has become so combustible. The next major stage will be the competition litigation. The court will ultimately have to determine what happened, what role the various Coolmore entities played, whether competition law was breached, and whether any damages are justified. Until those questions are decided, allegations should remain allegations. That is particularly important in a case involving reputations as powerful as these. But whatever the eventual legal outcome, the story has already revealed something unusual about modern Irish racing. The world of thoroughbred breeding isn't simply about horses. It's about land, bloodlines, veterinary expertise, stud farms, capital, obviously, networks, and in some cases, enormous concentration of commercial power. What began with 750 acres in County Tipperary has become something much bigger. John Magner wanted the Barn estate. Maurice Regan offered more, and a legal battle followed. Magner lost that case, but the relationship of the two men did not recover. Instead, the dispute moved from the land to the horse business. Now it has moved again into competition law. And that leaves one final question. Was this simply a personal feud between two billionaires, or has the Barn estate dispute exposed a much bigger question about who controls access, opportunity, and commercial power in Irish thoroughbred racing? That question may now be for the courts to answer. The competition proceedings remain ongoing. Allegations made by either side have not been finally determined unless expressly stated otherwise. Sources for this are the Irish Times court reporting, High Court proceedings, racing industry reporting, etc. Anyway, there it is, and thanks very much for listening.